Good afternoon, everyone. Please be seated. Sorry for the delay. We are back on the record in the state of Florida versus William Woodward, case number 2012 CF 55504A. I'll note the presence of Mr. Woodward at council table with Mr. Eisenmenger and Mr. Robinson, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. Again, I apologize for the delay in getting started this afternoon. I went through the proposed jury instructions, and I'll give you all my rulings on some of the arguments that were made in regards to those proposed instructions. The first one I'll address is 7.1. I'm going to include the state's version of the introduction to homicide 7.1. That does track the statute and the standard instruction language, including pursuant to 782.02 of the Florida statutes and the definition under justifiable homicide. So we'll include that as the 7.1 instruction. Next, as it relates to the 6.1 instruction, the introduction to attempted homicide. I understand the defense argued that they only wanted this to be presented once in the 7.1 instruction, but again, I'm overruling that and not combining it with 7.1, and I'll allow for the state's version of the 6.1 introduction to attempted homicide to be included, which includes the language, tracks the statutory language as well. The next instruction is the justifiable use of deadly force, 3.6F. If I could have the attorneys approach, please. This is a version that the court has developed in conjunction with the two proposals from the state and defense. So if you want to take just a moment to look through that, and then I'll explain my ruling, and if there's any other, I'm not going to let you re-argue the issues, but if there's anything that perhaps is inconsistent or that I didn't incorporate, I will note that I'm going to have each one separate as to each count. To include them would be inappropriate, so it would be as to count 1, count 2, and count 3. Let me know when you've had a chance to review that, Mr. Respis and Mr. Eisenmenger. Has each party had an opportunity to at least review it briefly?
Well, I'm looking for what's not in the
Is there something that was excluded that you think needed to be included?
Well, I mean, I'm assuming that the adopted modification of prior precedent. Yeah, if you find him because of facts or prior difficulties, you're hindering. It looks like you, I think you put who because of threats, didn't put for prior difficulties. And then went on from there. I'm assuming this was a defense requested instruction. This is the first line. So we're on page second last page, I believe.
Okay.
Difficulties with.
Okay, so you suggest that we add the, or prior difficulties with?
Well, I think that's the standard language. I always encourage the court to stay with standard language unless there's a reason.
Right, and I tried to do that. I took the state's version, the defense's version, and I understand that the state is even objecting to the instruction altogether, but I'm obviously overruling that objection. I am, again, allowing for the instruction to be read as to each individual count. So we'll have one for count 1, one for count 2, one for count 3. And so in going through this instruction, I utilized and incorporated 8.7a about aggravated stalking pursuant to 784.048 subparagraph 3, specifically utilized the statutory language of forcible felony under 776.08. The conspiracy, again, overruling the state's objection and including that and incorporating to the extent that it tracks the language under 5.3 instruction 777.04 subparagraph 3. And then the principal instruction 3.5a, and pursuant to 777.011 of the Florida statutes to the extent that it tracked that language. And I think you all were going to perhaps propose alternate language to the paragraph about the use of alcohol or drugs. Is that something that you all are going to present to the court?
I would just say voluntary intoxication does not excuse the commission of criminal act by reentry.
Are there any
There's
objections?
not a limitation in Florida law anymore.
Defense have any objection to that modification?
I like the language the court used. I have no problem if you want to add the voluntary intoxication as an excuse. That is a current state of law.
Okay, when we first... You want me to add a separate sentence that... Okay. Okay, so as it is worded then, state's agreement, but for the other objections noted.
I object to the entire instruction because don't have an issue with telling the jury that
Are you proposing different language then, Mr. Respis?
I did.
Okay, does the defense have any objection to, second to the last page, adding who because, second paragraph down, who because of threats or prior difficulties with adding that? Okay. All right, anything else from the state in regards to 3.6F? With that minor change that we just discussed to that paragraph, second to the last page, and what I can do is have my assistant email it to you all, and you can make the modifications accordingly as then counts 2 and 3, with that change similarly made to each of those paragraphs in each of those instructions. So I'll have her do that. Send her a message, please. Ask her to send it. And then you all can review the final version. Finally, as to the defense's request for 3.6C, the psychotropic medication, although it added language that was not included in the original, I'm going to sustain the state's objection to that and not allow that to be presented. And that's based on my review of PV versus State, 766 Southern 2nd, 1120. It's a Second District Court of Appeal case from 2000. That the defendant, Mr. Woodward, is competent. There's been no abnormal conduct or behavior by the defendant for the jury to observe, and there was no evidence presented to support that he is currently taking medication, which is also part of that proposed instruction. So we will not include 3.6C. Otherwise, I believe all other instructions we went through and were agreed upon. So with that modification of 3.6F, as noted, adopting the state's versions of 6.1 and 7.1 you all need some time before we bring the jury in and give them a close? Okay, so how much time do you need to get that together?
I guess that's the charge. There's really one charge. That's not a force charge.
Okay. Okay. We're proposing this morning to have that as a court exhibit. I'm fine with that as well, to make that a part of the record, so it's clear.
I asked our
Okay, so what we'll do then is we'll mark, and this is the version that was presented to the court this morning from both state and defense, the state's version as Court Exhibit 7 and defense version as Court Exhibit 8. Just, okay, that would be helpful. Madam Clerk will mark those. Have you gotten the message from Ms. Anderson yet?
Okay.
No?
That's training and save my office drive.
All right, so you want me to take, what, about a 15-minute recess?
When we get that, it'll probably take us about 10 to 15 minutes to get everything squared away after that.
Okay.
I'm going to go ahead, just want me to give this to the court. This is the defense.
Yes. We'll take a 15-minute recess then. If you all need a little bit more time, let the deputy know, and then we will resume. I'll give the closing argument instruction, and we'll go from there. Thank you. We are back on the record in State of Florida versus William Woodward, case number 2012 CF 55504A. I'll note the presence of Mr. Woodward at counsel table with Mr. Eisenmenger and Mr. Robinson, and the presence of Mr. Respis on behalf of the state and Mr. Shiner. Did you all have the final version modified?
I found some things that I have some questions about. Trying to sort this instruction.
Okay.
And I know this is one that you crafted from looking at everybody else's work.
Correct.
And it's the justifiable use of force that I'm having the issue with, so I want to talk about that. And it is on page 4, second paragraph. Because I want to know what you mean by something.
Just one moment. Let me find my notes. Okay, I was waiting for a final version, so do you have one that I can follow along with? Okay, thank you. Okay.
So I think it's
All right.
page 4.
3 copies do I need? That's count 1, count 2, and count 3. Okay.
Right, and they're all the same except for the names of the victims,
Correct.
right?
Okay.
So in that paragraph I'm referring to is page 4 of the instruction, paragraph 2. The language that I'm having an issue with is acted in conspiracy with another person or group, or that one or more. So at that point, it should be the individual. It should be, because if it's Bruce Blake on Roger Before, then that's not right. And if it's Gary Hembry, I mean, they can't pick all 3 for each of them. It has to be as to the individual. I mean, you could.
Are you proposing that the second line we exclude Roger Before and or Bruce Blake?
Or that, well, you're going to have to do something like this. If the defendant who, because of threats or prior difficulties with Gary Hembry,
Or that he acted in conspiracy with...
or that he acted in conspiracy with another person or group, or acted as a principal for another person or group, then that would based on the instructions. But the problem is if you give 3 names there, and then you say one or more of these, and it could be someone other than the person in the count, and I think you're going to confuse the jury, because it confuses me.
I thought when we went through these, there was no objection.
Oh, no, I was objecting to all the,
I understand the state was objecting to the entirety of the instruction and even a little conspiracy argument, but,
I was objecting, Judge, to them putting anything that went beyond the scope of the standard instructions in the line. That's what I was proposing, but if we're going to do that, then I think we need to do it so that the ruling is that you can do 3 separate ones, okay? And if we do 3 separate ones, then we need to do them individually by name, and then if other people are principals, then they can make those findings and hold the individual that is in the account responsible for their activity.
depends if it's not.
Or back to conspiracy with another person.
Right.
Finally, used the way. I don't have strong feelings one way or another. I think this is not confusing. I think it's very clear. Very being told these are the 3 major players. There may have been other people, but if the state wants it broken down to 3 separate leading.
Problem with the instructional naming names, they imply that Mr. Henry is not involved in any way. And to reject Mr. Henry's argument completely adopted for the other 2. In this count, they define Mr. Henry as the otherwise included victim because it says Bruce Blake or Ronnie before, they're going to have to find the other way. It says if one of these 3 or anyone else would be done, it has to be. I mean, this is why I didn't catch it before, because before it said 1 for each count. And then as I was correcting it, I realized that all the names. So it really needs to be individually counted names so that those considerations. And it goes beyond that in the next paragraph and the next page.
I see that.
Right. I was getting ready to go to the next page because the same problem comes about. I mean, if they determine that they're principals, when you do the first full paragraph on the 5th page of the instruction, it should just be the individual named, and then, or if you determine that Gary Hembry, Roger Pecor, and or Bruce Blake were acting as principals, you may take into account the relative physical capacities of that group. Now, I don't know if you want to do it individually. I mean, the heights and weights we've gotten is on those 3. Yeah, those are the 4.
Judge, if I may interject.
You may.
It becomes painfully obvious at this point that we're not going to be able to complete closing lines. I would suggest that we release the jury in the morning, they spend the time necessary to get the jury instructions correct, and start fresh.
I want the instructions. That's critically important that we get the instructions.
I know,
correct.
and I received the revised versions from the parties just this morning.
I understand.
So, you know,
I'm not criticizing, I'm just
We're all
trying.
working together to try to get this right, so.
I see no reason to make it very stupid while we are in the
Okay. May I have the attorney's approach for a moment, please? All right, let's go ahead and bring the jury back in, please. Please be seated. Jury is present in the courtroom once again, and ladies and gentlemen, did you follow all of my instructions over the recess?
Yes.
Is anyone aware of any violations of any of my instructions? All right, I asked earlier about you all staying late, but we're actually adjusting the schedule a bit, and we're going to send you home for the day. I'm going to ask you to be back tomorrow morning, Tuesday, at 8:20 a.m., 8:20, so that we can start promptly at 8:30. So I will again give you your recess instruction. We'll break until tomorrow morning at 8:20, and during this break, you must continue to abide by the rules governing your service as a juror. Specifically, you are not to discuss the case among yourselves. This means no discussions about the case whatsoever, no matter where you are, including the deliberation room. Do not discuss this case with anyone else or allow anyone to discuss it in your presence. Do not speak to the attorneys, parties, or witnesses about anything. Also, do not conduct any research regarding any matters concerning this case. You must avoid reading any newspaper headlines and articles relating to this trial or its participants, and you are to avoid seeing or hearing any television, radio, or internet or social media comments about this trial. So with that instruction, you all have a nice afternoon. We'll see you tomorrow morning at 8:20. Thank you. Please be seated. All right, so I'm clear on the state's argument. Does the defense have any other objection to the requested changes that each of these, since I have already ordered that they need to be individualized as to counts, that we modify the language to specifically as to, for example, count 1 with Gary Hembry, and making those modifications accordingly? I'm happy to read into the record what I think we need to.
Without waiving trust, the only language that still sticks out in some contrary experience in the law is the last sentence of page 4, starting depending on when you do the retreat. I don't believe that's actually.
That is the law under 77601. Well, look at the 776012 language.
I understand that. I believe the law has the right to be felonies being committed. That's probably what happened. It only talks about one situation. That's what we're talking about. Lack of that's my addition.
That was in the defense's proposal.
Maybe so. It's
Okay.
fine. We can just-
So you're asking me to,
It says right, here's what the statute says. However, and I'm just taking the last line of the paragraph that leads into the 1 and the 2. However, a person is justified in the use of deadly force and does not have a duty to retreat if, 1, because 2 doesn't apply, he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, which doesn't apply, or to prevent the imminent commission of a forcible felony. So that's the language in the statute. I think that's what the jury should be told. Well, he didn't. There's no.
sorry, or, just so I'm clear, what is the defense now modifying the request to be? Or,
After the word imminent, you add or a forcible felony that is being committed.
there's no reference to the duty to retreat. So is the state objecting to this additional language the defense is now asking for? So that that last sentence would read, however, the defendant had no duty to retreat if the danger was imminent or a forcible felony is being committed?
And you want complete language?
Are you asking this defense?
You want no duty to retreat language in here because I don't think it's physical.
I actually would agree with one way or two.
What's that at?
So, page 4, paragraph, based on appearances, any people who that.
Based on appearance. However, the duty, the had no duty to retreat information. That's what, see, I don't get confused over looking at page 1. That's the language you're concerned about?
Yes. That's the language.
So the defense is now proposing that we just strike the entire last sentence of that paragraph.
Either one of those options, either add it or felony, then it was strike.
Are you asking that not to say nothing about the duty? I don't want to deal, but here's the thing, I don't want to deal with this case issue. We've already dealt with the 3850, on the third last time period. And well, I put the language in there like that because they hadn't, in 2014, I believe they modified the, statute to make it practical language similar to that in 776 and really changed the statute. At this time, the individual did not have a duty to retreat if the danger was imminent. It was a law. And that's what the statute is. That's why I put that in there. Because it says something entirely different, which is you can't be committing a crime, you can't be committing a crime, and you have to be in a place you have a right to be. It wouldn't be good for this. So I couldn't think about that.
I'm sorry, Mr. Reiner, did you have something you wanted to add?
I'm just going through the instruction that probably should be put line by line through this one, because it is a compilation of outside of what is in.
That is correct, but at the same time, many of these are coming from other standard instructions.
I understand.
So it's not as if we're just
No, I know, but I wasn't.
reading our own instruction.
So if I'm just going through this, if I'm looking at that paragraph that's after the reference section, would it feel what we're justifying specific force, threat, force, force, threat of force, necessary, other ones, I think that prevent the prevent the actual
And if you want no duty to retreat language there, I don't expect that language to be there.
Well, that's where it's referenced in the standard instructions, so.
It is. I don't object to it. This particular fact pattern, I don't
Yeah, I don't know that, I mean, all right, well, let me ask this question. So whether we leave it on page 4 or we move it up to that paragraph, does the state have any objection to the defense's request to either modify it as noted with the forcible felony language, or does the state have any objection to that?
What language do you want? Maybe referring or imminent or referring?
However, the defendant has nothing to do with include this evidence or forcible felony.
How is that? That's not the best. So, I think that's the way I'm trying to try.
Okay, so we're now going over issues that were not raised earlier, so. Defense's response? Okay, well, I know that the proposal from the defense originally, the word imminent was purposely left out. I indicated that it should be added, and it is in fact added. So you can. Okay, and where do you propose that that be added?
However, here, standard instruction, instruction, that language says something like, or the defendant had no duty to retreat, he was in a place he had the right to be in violation of law.
No, that's wrong. What you said is right.
Right. So I changed that language to this, which I believe was consistent with the statute, but if we just say, however, the defendant had no duty to retreat, if no duty to retreat if the act is to prevent imminent threat of great bodily harm or the imminent commission of a forcible felony.
And that's the standard language from the 2012 version?
Yes. So let's just put the whole language.
All right, well, I would ask that what the state is proposing, perhaps you can note it, put it in bold so that I can look at it more carefully and see where you're asking for. And again, this was not a change that was discussed or requested earlier, but but the other issue that the state brought up before we brought the jury back in, decided to defer the closing arguments, were the subsequent paragraphs that included the other victims' names. So I'm looking at, for example, page 4 on the count 1 instruction, the first full paragraph. If you find that the defendant who, because of threats from or prior difficulties with Gary Hembry. So the state's requesting that we exclude any reference to Mr. Pecor and Mr. Blake, correct? Okay, well, here's what I might propose, and we'll see what you all think. But I agree that because I ordered that they be separate and distinct instructions, that it needs to be modified. If you find that the defendant, who because of threats from or prior difficulties with Gary Hembry, or that he acted in conspiracy with another person or group, or acted as a principal for another person or group, have reasonable grounds to believe that he or another was in danger of death or great bodily harm at the hands of Gary Hembry, or that Gary Hembry was committing a forcible felony, or that Gary Hembry was about to commit an imminent forcible felony, you may consider these facts. I didn't read the rest of the paragraph, but it is very wordy, but covers the bases.
Here's the correct majority would have to use. Get down to act as a principal of another group, then it should be William Woodward. As William Woodward has reason to believe, but it's William Woodward we're talking about. Very different or other. So we need to make sure that we do this. Then, line between the prior difficulties of Gary Hembry or that Gary Hembry acted conspiracy with another person's group, or Gary Hembry acted as a principal of another person.
So it's clear as to who the he is and the references. I agree with that in terms of making it very clear as to those issues of when we're talking about the defendant specifically, or when we're talking about Gary Hembry and or on the second one, Mr. Pecor and or Mr. Blake on the third. So the defense have anything else to add to that?
William Woodward had reasonable grounds to believe he or another was in the death or great bodily harm as Gary Hembry or another person or group.
Gary Hembry. Sure, if it's, or, then that means he's not involved. If it's and, he is. And or.
Do you all want a few minutes to come up with some alternative language that satisfies what the court's intention was in terms of separating out the counts, to ensure that it's consistent and that the references to the defendant are consistent, the references to the victims are consistent, and adding in the issues? Do you all want time to maybe redraft this? Would that be helpful to both parties? All right, and then as far as the proposed language that the state is requesting or the defense is requesting in terms of tracking the 2012 statutory language about the duty to retreat, I guess we can discuss that unless you all come to some agreement on that. But if you would just note it in bold if there's no agreement on how it should be worded. But I'll go ahead and take another recess so that you all can flesh out the language as to count one, and then once we have that ruled on, then we can make it consistent with counts 2 and 3. So how much time do you all want to do so?
None of the language should stop right there. Period. So the whole
If we find, I think this is justified, that this was a reason for us to be death or bodily harm, we consider this back in terms of whether we actually
I understand, but I also included the proposed language that the defense requested in terms of the conspiracy and those acts. So that was added in,
Like,
tracking,
how can we do that?
I'm sorry?
That's what I'm saying, we can do that.
Just make it a separate sentence.
Well, let us work on it, we're gonna try.
Okay.
I understand
How
what
much time do you all want to work on these to see if we can get the language that satisfies the parties, and if not, then I'll make a further ruling? How much time does the defense and state want? I'm sorry? Agreeable to the defense? All right, I'll take a 20-minute recess. Hopefully you all can come up with some alternative language. If not, like I said, I'll make a ruling, but we'll be in recess for 20 minutes. Thank you. All right, we're back on the record in the state of Florida versus William Woodward, case number 2012 CF 55504A. I'll note the presence of Mr. Woodward at council table with Mr. Eisenmenger and Mr. Robinson, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. All right, so the state just approached with a modified version noting changes in bold. There was also a version emailed to my assistant from the defense, I suppose?
Yes.
Did you look at that, Mr. Shiner?
We're at it right now. We looked at some of them.
Okay, so now I have, again, two different versions to look at.
Yep.
I thought we were going to try to work together to see if we could
We
reach
tried to
some.
work on the first language, we weren't agreeing on the first language, which is the threats of prior difficulties, we weren't getting there, so it's like we spent,
Okay, because I received this version and I thought that this might have been the proposal, but
no,
I have not had an opportunity to review what the state's proposing. Does the defense have a copy of what the state's proposing?
I think so. I'm looking at something that they emailed us.
Okay, so which version do we want to discuss first?
well, why don't we start with paragraphs we want to talk about, then we can look at the version.
Okay? Page 4 is where the first proposed changes.
Let me go back to
noted.
the state's version. Judge, why don't we start with the state's version? Because I know they disagree with ours, and I'm closer, I think, to agreeing to theirs than they are to agreeing.
Okay. And you all checked the 2012 version of the instruction and statute in regards to the duty to retreat
Well,
and your proposed language, Mr. Respis?
We've looked at those things before we started this exercise, Judge. I have some concerns about using 2012 language because it changes they made to that after because of some case law that came down from the board.
Okay.
And so I'm trying to do this the way I think that all the district courts are in accord now on how we treat 776.012. And I've tried to track that, what they're saying, I think.
So the way I typed that change up, and just for the record, we're on page 4 of that, the bottom of that paragraph. However, the
The
defendant...
last sentence of the first paragraph. Okay?
However, the defendant had no duty to retreat if, and then it's taken that language directly from 776012 sub 1, the 2012 statute.
Let me simplify it, Judge. I think I can live with their language.
Okay, so the defense is in agreement with that last sentence then in the top paragraph. But for the rulings that I made previously.
Right. I'm not waiving any of my prior rulings.
Okay.
I'd always get paranoid at this stage. But
I'm not
in terms of the compromise language, I can live with this as compromise language.
And that's where I got it, 776012 sub 1. That's the language.
Okay.
I mean, I'm not talking all the way through. I'm talking about their whole instruction. I can live with.
Oh, the whole instruction, so the way it was revised, because I know,
The way they sent it to me.
okay. Let me ask one question, let me see if I can find the reference.
Let's make sure we don't have typos, because we were working on that right into the rule.
Yeah. I'm not sure whether it should be commas or semicolons. I'll defer to somebody with greater grammatical skills than mine.
Let me just read it. You find the defendant because of threats from, root prospect.
Okay, there is no reference to Gary Hembry committing an imminent forcible felony.
So, because that's not in that instruction. The instruction is about prior threats and difficulty. They're told about Gary Hembry committing a forcible felony and other parts of the instruction. This is about whether or not the defendant had a reasonably believed because of prior threats or difficulties to Mr. Hembry, or Mr. Hembry and his co-conspirators, or Mr. Hembry and his principals. So that's why that's.
Okay, so the state's had a chance to review it again. There's no modifications needed, and the defense, but for the court's prior rulings, is comfortable with the language presented in that next paragraph?
Yes.
Okay. And then the paragraph about the reputation,
I'm comfortable with the language, again, not waiving my previous request, but as a compromise language, I'm comfortable with it.
you don't need the comma after Gary Hembry in that paragraph.
Where you at, Judge? That's all.
Do you find that Gary Hembry had a reputation of being violent and dangerous, or that Gary Hembry and any co-conspirators or principals had a reputation of being violent and dangerous, that this reputation was known to the defendant? You may consider this fact in determining whether the actions of the defendant were those of a reasonable person in dealing with Gary Hembry. So, again, but for the court's rulings, the defense is agreeable to that language.
Right.
Okay?
And we're doing this language based on the rulings the court made that were different.
Understood. So, but for the rulings of the court, the state is proposing this language since I have indicated that we are going to present such instructions. So, all right, and then the next paragraph bolded is in considering the issue of self-defense. All right, so again, Mr. Eisenmaker, just to be clear, but for the court's prior rulings, then you're okay with the language as proposed in that paragraph about self-defense?
Let me look at that again.
Okay?
Refer to the second to last paragraph, Your Honor.
I'm sorry, I'm
We determined.
First
talking
full
about
paragraph on-
taking into account the relative physical abilities and capacities.
Yes, I'm comfortable with that language,
I don't think
without
anything
waiving
else-
any of my previous objections.
Because I don't think any of the other language is modified, so. Okay, so does anyone wish to do a final review of this 3.6F and the final proposal from the state, and again, subject to the court's prior rulings on state and defense's requests? Anything else from the state?
The only question that I have, we've been using the Gary Hembry. Gary Hembry, I think, is count 2, correct? A 1? Okay. Of course, dude. Never mind it. No, I was just being.
Count 1 is in
I don't
reference
have the
to,
indictment in front of me, so I'm not sure which.
Gary
count
Hembry's,
one.
Gary Hembry's 1,
Course 2,
Course 2.
Blake is 3.
yes, that's what the indictment shows, so.
All right, then I'm
Correct.
fine. Then for, as to count 2, we're going to substitute every
Right.
place we put Gary Hembry, Roger McClure.
Right.
Got it.
In fact, we're gonna try and get all that done before we get out of here.
Has a copy been presented to the defense as well? Okay.
Are you gonna want copies for the jury? Read along with you?
Yes.
Is the state requesting
Further
that?
notations.
I've seen that done, I've seen it, mostly I've seen that done lately. But however you want to do it, sure.
Defense requesting that the jury receive a copy of the written instructions as I read through them, or only until after I send them to deliberate?
They're gonna get it anyway, so I'm good either way. Since they would like to have them while you're reading it. I'm okay with that. The only real concerns I have when that happens is different people read at different speeds.
Right.
And may kind of leave them behind.
I mean,
That's why I usually prefer they just, you tell them
Listen.
you're gonna get a written copy
Right.
and then have them listen.
That's generally how I have presented the instructions. And I do find that sometimes if you give them a written copy, then they'll want to kind of read and follow along, but they don't always necessarily listen then. So we will not present the copy of the written instructions until they are actually sent to deliberate then.
Okay?
All right, so do we have a final version of all of the instructions, or is that something the state's still working on?
Judge, there may be a grammatical error.
Okay, let's correct
The
it.
use of alcohol or drugs extent to no passions, tensions, perceptions.
Difficulty to spell wrong.
Is it, is not excuse faulty? Oh, that's fine.
No, a group or party to which he
Oh, yes. Yeah. If you look at page 2, the voluntary intoxication, there should be the word he between which and were acting. He was.
And Mr. Schneider, bottom of page 2?
I think I printed the wrong one. Were you actually on page 2?
Page 2.
Bottom
I
of
th-
page 2.
If you look at the last sentence of the use of alcohol paragraph,
Or another group?
make
or
it
party?
grammatically correct. It should, does not excuse the commission of it. I'm sorry?
Acting as a principal.
Yes. Yeah, to which he was acting as a principal. Yes.
And then there's a misspelling, Mr. Schneider, did you say?
Oh, I fixed it, but I'm not positive now. I have 3 different documents open.
Can we print out a
state's working on a final version? Okay. I'm assuming you already included the 7.1 state instruction and the 6.1, so I don't know that there were any other modifications. Does the state have final version?
I think I'm just waiting for Mr. Shiner to print out a set like. Is this the only change? Let me make copies of it. Did we get the introduction of homicide?
Right, so that's what I'm asking. Does the state have a final version? Okay. All right, we're going to make some quick copies, do a final review, so everyone's in agreement. I also had my assistant contact court technology in regards to the laptop that you all requested with the headsets that will go back to deliberation room with the jury. I know the jurors are coming back so that we can start at 8:30. Can you all come in just a few minutes early to ensure that the folks can, Mr. Goddard, I think specifically is going to assist, that the videos are able to play on the laptop and it's appropriately in the condition that you all request, and that it must be as far as not having access to any other programs. So if you all can just come in a few minutes early, and I'll ask them to come in and ensure that the videos will play if the jury wishes to review those.
Our interest is mainly that they don't have access to it.
I understand that, but I also want to make sure that if they want to utilize it, that it will in fact work, rather than them having to write us a note and indicate it's not working. Attorneys may approach. Hopefully this is the final version. You all want to take a look at it, make sure that it's in accordance with the court's ruling. They have to make some modifications.
I'm reading it now for typos, Judge.
It has not been fixed. This is the final. Yeah, I do have a typo. We didn't change that, acting as a principal.
Justifiable?
Okay,
Yeah.
let's be clear on what we're talking about, which instruction.
If you
what
go
page.
to
I
the,
haven't got there yet.
okay,
I'm on
tell me when you get to the page that starts with aggravated stalking.
On 3.6F,
Yes.
is the state there, or?
I found one before
The state is emailing my assistant with changes. Is that?
No, I was
Emails?
just thinking, that was the final.
that was a while ago. It was when you walked in here.
324.
No, that was just final, what I printed.
All right, making sure. Okay, so there's a typo that the state believes needs to be corrected.
On 3.3E, in the attempted.
As to count 3,
Is it, what is this? Oh, it says to count 1. So it's asked to count 1.
it'd help if these pages were numbered, wouldn't it? So 3.3D as to count 1? Find that. first time I see that it shows up is as it relates to count 3.
It's the second paragraph for some reason.
Okay, what I'm saying is the first reference to 3.3D is as to count 3 in my packet. So,
Yeah, that's going,
That one's correct.
that one is, yeah, that one's not.
is that out of order?
No, it's in the lesser section.
Because
Okay.
we don't get the firearm stuff on the first two counts, it's on the lesser.
Okay. Okay, so we're talking about 3.3D as to count 1. All right, what is the correction?
Left out the word,
Third paragraph, if you find that William Theodore Woodward, second-degree murder, is what it read, it should say committed.
Are you all on that page? 3.3D as to count 1?
I am looking at 3.3D,
I see it now.
third paragraph.
Okay, so we
Yeah,
have
so
one
it says
page
to
to
count 3
replace
as well.
that.
Okay.
Okay.
Wait for it.
All right, are we on to 3.6F yet?
not there yet. We'll get there.
Okay. Is there another correction?
It's the same as the count 2.
All right, so 3.3D as to count 2, we have to add the word committed, the third paragraph. Ben's following along on that one as well?
Yes.
We are.
Okay. Thank you.
Okay, I don't see it. In count 1. The justifiable around aggravated assault.
Okay, well, before we move on, unless I have, once again, a wrong version, I have 2 copies of 3.3D as to count 3 included in this packet. Yes, I should?
There's multiple lesser.
Okay. All right, so they're addressing then the attempted second-degree murder versus attempted first-degree, okay. All right, just want to make sure that we're going through page by page and we're not missing anything. All right, so now we're at the 3.6F,
That's where I've got.
okay?
On
All
count
right, so
1.
Mr. Eisenmenger, the change, or you had a concern on the page starting with aggravated stalking at the top?
Yes, if you go down to the bottom, third line from the bottom should read, to which he was acting as a principal.
Right, we talked about that, so can we make that modification?
And that repeats itself in all the various versions.
Okay, right here. Did, we almost did it. Almost got it.
And are there other places where we need to modify, Mr. Eisenmenger?
No expiry date so far.
Is that the only modification then? 'Cause I think everything else reads
Yes.
appropriately. Okay.
As I said, it just repeats 3 times.
All right, so, I'm sorry?
It just repeats for each version of this. Same mistake was made as the count
Okay.
1, 2, and 3.
So if we can just get those pages inserted then? Are you able to just print out that page?
Well, it'd be different
Later, when it says to make the correction.
as the name changes each time.
No,
That should, will I do it?
I got it.
Oh. Yeah, we should do it. Very good.
Do you have a copy for the court?
Do,
May I approach? Making sure my pages aren't mixed up. Thank you.
twice less than 3.
Thank you. All right, 3.7, we're up to that one. You all had a chance to review the remainder of these instructions, and are they in accordance with court's prior rulings?
Rest look good.
agrees?
I mean, I'm not as fast as he is. I mean, every time I do these trials, Judge, we always miss something to try and get it. We always seem to miss something.
Defense also satisfied with the verdict forms that were modified?
Yes.
Okay, thank you. And as far as the 4.2, that really didn't necessarily be included in their written version. You agree?
Yeah, that doesn't go back.
Okay.
That's not something you're gonna be reading to them until after the trial.
Right, so I'm going to not include it in my version, so. All right, so the state's still looking through them? Let me know when the state's had an opportunity to review them all the way through, please.
This doesn't have.
What is your concern, Mr. Ruskin?
Oh, I'm just thinking about Judge Alva. That's standard language? Pull that up. Pull the instruction. Where's the book?
You mean in addition to 3.10?
I'm looking at 310, 6. Judge Alva was just tried a case with me in November, and she's telling me the standards are different than what they were. Because we tell them, I just was reading through and they go, oh, yeah. It's in there, 6. Did we put 7? Okay, well, there were some notes here, so I guess that's appropriate. Are we okay with 7 on 3.10 as well?
Yeah, I'm just looking at that as well, because obviously, well,
They attempted
they
to
did,
ask
they
for-
attempted. even
Right,
if it
no,
was-
that's why I put it,
That's why you included it.
put it in, because
So it is appropriate. Anything
Okay.
else, Mr. Respis?
I was just like, Judge Alva doesn't like having the unanimous instruction there because it's given in a verdict form, I guess was her reason.
still part of the stand.
It's standard stuff. I just wanted to make sure, because she had me convinced we were wrong.
All right, so the state is now satisfied as well?
We are.
Yes.
Okay. All right, so I have the final version. I'll have copies ready and available tomorrow. Obviously, we have asked the jury to return at 8:20, so we can start on time at 8:30. Let me also inquire, Mr. Woodward, you're still under oath, sir, and were there any other jury instructions that you asked your attorneys to consider?
No, ma'am.
And again, just for the record, we're preserving all our previous objections.
So noted.
Yeah, I would raise mine as well.
And that's also noted for the record. Mr. Woodward, did you have an adequate opportunity to discuss the jury instructions with your attorneys? I'm sorry, we're having a,
Current state, Your Honor, or the argued state, or the
Just-
messed up state?
just generally, did you have an adequate opportunity to discuss the proposed instructions, proposed jury instructions with your attorneys?
Are you happy? That's all she's asking.
I'm fine, Your Honor.
So you had enough time?
I've heard all the arguments, everything's fine with me. Yes, everything's good.
Okay. Subject, obviously, to the objections noted by both parties as we went through those. I do have the final version then. Is there anything else that we need to address before we recess for the afternoon? Anything from the state? From defense?
No, ma'am, thank you.
All right, we will be in recess until tomorrow at 8:30. Thank you all. Make sure you get here.
Right decision to let the jury go.
8:20 is when you want us here?
Well, the jury is coming back at 8:20, but make sure you also come in a few minutes so that you can assist court technology in ensuring that our technology needs are being met. Okay? All right, thank you all very much.
My headphones.
Okay. Right. Okay, thank you. You all have a nice evening.